Right from the start, this hearing exposes a problem that shows up in countless custody disputes. The parents have already spent time in mediation and reached agreement on most parenting issues, yet one unresolved conflict continues to dominate everything else.
All right, Mr. Becker is present. And let's see this off your parent. This was kind of a status conference to address what the parties are currently doing and following as far as their orders. I do see, so sir, you recently attended mediation, is that correct?
Yes, sir.
And did that mediation address all of the parenting time and
We agreed to mostly everything. There's still a few issues down at the bottom of that mediation order.
all right, I guess I'm confused. So one part says the parties do not agree to the final decision-making authority being with either parent and ask for the courts to rule on this matter. What does that mean?
So as of right now, I am the primary parent, especially during school year. She goes with her mom week on, week off now, starting the summer schedule. I have been making most of the financial or the medical decisions. She doesn't agree with that. I've been bringing her to the doctor. I got her set up on some medicine that has excelled her behavior in school and her academics. She does not agree with that. So obviously, if neither one of us, or if we don't agree with each other, then we have to have it taken care of by you.
All right. I was reading that portion a little bit differently because I do see another portion that talks about medication, but
Correct.
I mean, ultimately, you guys currently have joint legal custody. So there's no motion to change that, I don't believe. Is there really even a motion in front of the court at this time?
There was not.
Okay.
It was a friend of the court matter to consolidate all the parenting time orders.
All right.
Yeah, so she just does not agree with me making the medical decisions.
So that would require one of you to file a motion to address that issue. But you're asking, well, let me put you under oath real quick. Would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right. So, sir, is it accurate that you attended mediation? It looks like on June 2nd of this year.
Yes, sir.
And Ms. Scott, your parent, was there as well.
Yes, sir.
And the two of you reached an agreement regarding several issues: parenting time, extracurricular activities, telephone communication, the holiday schedule, communication, and parental conduct. Is that correct?
Correct, Your Honor.
And it's your understanding from your participation in that mediation that she was in agreement with all those terms?
Correct.
And you guys already started to follow that parenting time agreement?
We have.
A quick look through.
Like I said, the biggest issue that we had was the medical. I've been taking her to her doctors. I'm the one that schedules her dentist appointments. Her mom currently doesn't have a vehicle, so her doctor is up in Indian River, so I take her to all those.
Where do you guys, I see it. You guys make exchanges at McDonald's, is that correct?
Yes, sir.
All right, and that's where you do all of your exchanges?
Yes, sir.
All right, so what I'm going to do then, and sir, do you believe this agreement is in the best interest of the children?
Yes, Your Honor.
I'm sorry, the child. All right, so the court will indicate then that the parties will follow, that their mediation agreement will be their terms. The parties continue to have joint legal custody. That has the,
Because I believe on the order it has me making the medical decisions. I just have to let her know what is going on. I believe that's what it says. I'm at work, so I don't have all my paperwork right in front of me at the moment.
well, let me see if I can find the paper that says. First order I see was from 23, gave the parties joint legal, joint physical. Did not mention anything with the medical. Is that something you guys agreed to maybe in a mediation?
No. It was the last time we went in front of you, I believe. It says, father will make medical decisions and follow doctor's recommendation and keep Jaslyn pretty much in the loop. Her biggest thing was she refuses to give Adeline the medicine that the doctor has prescribed. I've taken her to therapy to get her diagnosed with ADHD and ADD. Her schooling, she was failing school, her behavior outbursts. As soon as we started her on this medicine, it
Sir, the document you just read off, what's that dated, or where's that from?
like I said, I don't have all the paperwork in front of me at this moment.
Oh, did you not just read off a document? I didn't know, because you made a comment about.
The conversation about medication becomes the true pressure point of the case. The father presents a narrative that links treatment directly to academic and behavioral improvement. From his perspective, the issue appears straightforward.
You made a statement that it says dad has.
No, I'm just pretty much, or I'm pretty sure that's what it said. Like I said,
I don't see an order indicating that. I went through all the things that are tabbed in blue. So the parties, so again, we're going to adopt the mediation agreement. The parties have joint legal custody. Dad has the primary physical. If there's some other issue to address, either one of you can file a motion to address that issue, okay?
Okay, so as for the medicine, then it just currently her doctor prescribes it, so we just give it to her then?
I am not saying that. I'm saying if you guys don't have an agreement, you need to file a motion, and somebody can file a motion. The orders indicate that you guys have joint legal custody.
Okay,
All right, thank you.
thank you.
Yes, Your Honor, I'm here.
All right, Mr. Stollard is present, and Mr. Stollard, this is your objection to the registration of an out-of-state order, is that correct?
Yeah, I don't really know what that means, though. I just can't afford the $700 something a month. I made a payment of $100.
Okay. Do you agree, though, that there was a support order for you out of the state of, I think it's North Dakota, is that correct?
Yes, Stark County.
Okay. And
I've been making payments on the touch pay, except for the last few months. But now I'm working again, so I just sent $100.
okay. Is there anything else you want to say regarding the objection that you filed?
I hired a lawyer when I was in North Dakota for $2,500. Then COVID hit and he took my money, but didn't do nothing. And I went to the court with a letter, and the clerk at the front desk in the courthouse office there said I could leave it there, but nobody's going to look at it. I have to mail it in instead of hand it to somebody. So I did that, and then still never heard nothing back. And it's been some years, and I've called child support in North Dakota to tell them. They said they're not going to do anything until September. Well, it's past September, and I haven't been able to even see the kid, not video him or anything. And I was his little buddy. Like, I took him to daycare, fed him, changed his diapers for the entire first year he was born. But then she started getting jealous of my daughters that are all grown. But because they're really nice and still love me, they wanted to get to know their brother, and she didn't want nothing to do with that. And
All right. Thank you, sir. So, issues as far as, parenting time and custody will have to be addressed through North Dakota. We're simply just asked to help North Dakota collect on any support amount. Mr. Stollard has acknowledged that this case did exist in North Dakota. for the support payment. I understand he indicates he might have some trouble paying the recommended amount, but step one is to address whether or not the out-of-state order should be registered. So I will deny the objection to register the order. Front of the court, anything else you think we need to address today?
No, Your Honor.
Okay. All right, so I will deny that objection to register it. As far as making payments, you can speak to a caseworker and have those discussions, but you may have to also address the amount and those issues with North Dakota, okay?
I'm confused.
All right,
So
what's the matter?
I guess I don't understand what I'm supposed to do, except for keep making payments.
That's what you're supposed to do, yes. If you
What-
want to address
all right, so if
other issues,
I
you
can
have to address North Dakota.
If I can save up for a lawyer from right here, is that gonna be okay for North Dakota? Because last time they told me I couldn't bring any out-of-state lawyer.
Well, to practice in a state, you have to be licensed in that state or get permission to practice there for that particular issue at that particular time.
So I wouldn't be able to hire a Michigan lawyer.
The final exchange leaves viewers with a revealing look at how overwhelming family law can feel for self-represented litigants. The father's questions are not really about legal doctrine. They are about navigating a system that appears larger than his resources. He wants a roadmap. The judge provides practical information but cannot become his advocate. That limitation often creates the most difficult moments in court. Judges can explain procedure, but they cannot build a party's case for them. The hearing ends with a reminder that legal problems do not disappear simply because they are complicated or expensive. Whether involving custody authority or interstate support enforcement, the system expects parents to follow the proper channels. The challenge for many litigants is not understanding their emotions. It is understanding which legal door they must walk through to address them.